a seminal judgment in that area, and better than all the judgments that came even before, after it. F versus F, I'm not sure if you remember, it dealt with child relocation disputes.
Yes, Justice Meyer was in fact the judge who upheld my judgment in the SCA.
In fact, before it went there are two judges who agreed with you and of course Satchwell J disagreed with you and took a very feminist approach to it. And I will tell you why I'm raising this issue with you. In that judgment, you raised a serious question, which none of the judgments, including the judgment by Justice Meyer at the time, and Jackson versus Jackson as well, they did not grapple with that issue because they took a constitutional element and the rights of women and all those things. But you asked a very important question in relation to how do we look at the custodial parent who wants to actually relocate with the child, and the fact that she particularly wants to relocate, does that necessarily mean that that is in the best interest of the child? And I'm not sure if other judges, including the Supreme Court of Appeal, has actually grappled with that issue. But not looking at it from a feminist point of view, but just looking at the child and the parents who are looking. I'm not sure, do you have any view in relation to that?
Yes, I must be quite honest, and I appreciate your stating that it was a seminal judgment. I did consider it to be so as well, because there was, at that stage, I think it was 1990, it's here somewhere, it was simply assumed that women should get custody. And if they were relocating, it was a matter of course that the children would go with the mother. But this was one of those cases where the father had an equal input into the child's life. And I thought that one can't simply look at it as, well, the mother must get custody of the child because she's the mother. It was a very difficult decision, I must admit, because these relocation cases are tragic most of the time because there's one parent that gets left behind. But if I looked only at the best interests of the child, which was the test that I applied, the child did not want to be removed from her father. The mother had the option of staying here. It was simply more convenient for her to go back to the United Kingdom, where she said she might have more support, but she had no concrete reason to go. And I just believed that it was in the best interests of the child that it's taken into account what her father offers to her as well, and that whereas the mother had the option to choose between the two, she was not choosing the one option for very serious reasons. It was simply a preference on her part. And I believe that it was in the child's best interest not to allow the child to go with her.
Well, I think that is their best case in child relocation disputes. I've played a very central role in my thesis as well, and I want to say thank you to that.
Thank you, Professor.
Thank you, Professor Marumohai. Minister Lamula.
No, I'm covered.
Thank you, Minister. Commissioner Dodovu.
I'm also covered by Honorable Nyambi, Chair of the session.
Thank you, Commissioner Dodovu. Commissioner Magwanishe.
Just one question. Thank you very much, Acting President. Good afternoon, Judge.
Good afternoon, Commissioner.
It is just a follow-up from Commissioner Steinberg. In your experience as a judge and as an advocate, how has the system made women to be agents of patriarchy?
Sorry, just say that again. How's the
How has the system made women to be agents of patriarchy within the legal profession?
It has certainly contributed to that. In a society such as ours, where patriarchy is so deeply embedded into our society, one has to realize the value of the participation and contribution that women can make to the system. And it is a barrier that has been up for much too long. The glass ceiling needs to be shattered. It has started to be shattered, but it needs to be completely destroyed. And when I gave you the example of men being looked at in the sense of they're competent just like that, whereas women have to prove themselves, that is proof of patriarchy. That is the assumption that people have. And to break that glass ceiling takes a lot of courage. I mean, I must have threatened to leave the bar at least once a week in my earlier years because it was so difficult. It was in the 1970s. I'm now really giving away my age. It was in the 1970s where it was simply unheard of. There were 6 women at the bar of, I think the bar was about 500 at that point. They were all doing matrimonial work, and I do not denigrate that in any way, but I simply didn't want to be put into this box of that is what you are going to do because we say so. So I wanted to escape that box, and I managed to do so. And I do believe, as I thank Commissioner Steinberg for saying, that I did have some influence on the progression of women at the bar and assisting them to break out of the cages into which they were put.
Thank you, President. Thank you, Judge.
Thank you, Commissioner Magwanishe. Commissioners Barnard and Bredenbach, any questions for the candidate? Yes, you may proceed, Commissioner Barnard.
Thank you, Judge Wiener. I noticed that you were on the panel on one of the Bobroff judgments.
Sorry, you see.
Around certain interpretation and transgressions of the Contingency Fees Act.
Yes.
And I know currently our minister is grappling with part of this as part of the South African Law Reform Commission's report that's lying on his table. Question is this, is how do you see the future of contingency fees in South Africa? What can work and what should happen in that regard?
I think that a contingency fee agreement in itself, there's nothing wrong with it, but I think it is being used by certain practitioners, or should I say it's being abused by certain practitioners, because at the end of the case, they simply say, well, this is what they've done. There's no checks and balances in that regard. And it has to be, I think, stringently regulated in the sense that if someone is going to enter into a contingency agreement, it needs more than simply this layman to sign a document saying they understand. There has to be something more that needs to be further regulated so that litigants know what they're getting themselves into. It can be checks and balances along the way as to each consultation or each appearance, because, for instance, in that case, they were simply adding a 15,000 Rand fee, general fee, to every case, every matter that they had, as I'm not sure quite how they described it, but every case had a 15,000 Rand charge to the client. So it needs to be regulated, it needs to be very well supervised, and judicial scrutiny is essential. And I think that was part of the Maswanganyi case that was decided by the SCA it was actually my first judgment in the Supreme Court of Appeal, where judicial scrutiny was deemed to be essential, especially when public funds are being dispersed. So I think that there needs to be more regulation and stricter observance of the rules, and perhaps this is where the LPC may come in, although I know they're very overburdened. But these sorts of things need to be dealt with in a very stringent fashion.
Thank you, Judge. Thank you, Acting President.
Thank you, Commissioner Barnett. Commissioner Breitenbach.
Thank you, Acting President. I don't have a question, just a statement, and forgive me for not switching on my camera. We're having load shedding, so I've got serious connectivity issues at the moment. Good afternoon, Judge Wiener.
Good afternoon, Commissioner Breitenbach.
I just have a sort of a statement. I just want to agree with Commissioner Nyambi that age is not the determining factor, and that old people do have things to offer. And just to mention that your comments about the glass ceiling, certainly yourself and your colleagues at the bar at that time, yourself, and others, inspired a lot of women, myself included, to get through that glass ceiling. So we owe you a great debt. Thank you.
Thank you, Commissioner.
Thank you, Commissioner Breitenbach. Judge Weiner, I see that your first acting stint at the SCA was in April 2019.
Yes.
And since then, you have acted for 9 terms in that court.
Correct.
And how many judgments did you write during that period?
I've got the note here. I wrote 15 judgments. And I think that 6 have been reported.
Thank you. I had the benefit of reading the record of your previous interview, and I couldn't pick up anything adverse,
Thank you.
unless I missed out something.
I hope not.
And what would your response be to those colleagues who believe that, or who have some reservations about your judgment writing skills, especially writing for the SCA?
Well, I started off with a baptism of fire. My first judgment was written for Justice Meyer and Justice Wallace. And he certainly taught me a few lessons in my very first judgment. When I looked at it, though, it appeared that it was mainly structural, not so much the content, but the structure that he felt needed to be changed. There were one other judgment that I had some problems with, I admit, and I went to discuss it with both Justice Ponnen and Justice Wallace, and we discussed it, and I worked it up with Justice Wallace. That was the, sorry, just let me get that. Umgeni water tariff matter, which Justice Wallace did change my original judgment quite substantially, which I accepted his changes, and in fact I suggested to him that the judgment go out in both our names. In fact, I first suggested to both Justice Ponnen and Justice Wallace that it goes out in Justice Wallace's name, but they both said that I had put in a lot of work into the judgment and they thought that it should go out in both our names. It was then overturned by the Constitutional Court, and that is one of the judgments that isn't here insofar as judgments that have been successful on appeal. So there were 4 and that were mentioned, and this is the other one that came out later, and so yes, there are 5 judgments in which my judgment has been overturned. So insofar as judgment writing is concerned, I think that I have produced good judgments. Most of them have been, other than those two, the judgments have been well received with certain structural changes. It's a stylistic thing, and a lot of some judges like to put up front what the case is about, and they're the legislation, and others like to do it differently. So it's quite difficult to follow sometimes because you're not quite sure which way the presider will prefer. But I believe that I have written useful and constructive and good judgments in most of the cases.
From that experience you had with those two judgments, can you now reassure the Commission that you can produce proper and well-written, well-reasoned judgments for the SCA?
Well, I believe so. As I say, I've written 15 judgments, and those were the only two in which I received quite a lot of assistance, which I took on. They were both very senior judges, and I accepted what their advice and their comments that they'd made, and I hope that I learned from that and have gone on to write much better judgments since my first two.
Thank you. Before we excuse you, is there any other thing that you wish
Sorry,
to...
AP, can I follow up from the question that the last question that you wrote?
Oh, I beg your pardon, Professor, you may.
Yes, I said, can I please, oh, I may. All right. Thank you very much, Judge. You know, the thing is, I'm getting some sense of unease with the way things are happening at the Supreme Court of Appeal, and perhaps one day we'll get a full sense of what is going on there. My discomfort is this. Judges are appointed to different divisions of the High Court, and they write many judgments. Well, we know writing, it's a different sport, right? And all of us have views on how other people write, and we can criticize each other, and that is fine, academically and in practice. There seems to be a way in which one writes for the Supreme Court of Appeal. And if one doesn't write in accordance with how one should write for the Supreme Court of Appeal, then the judgment might be thought, or the draft might be thought of not being proper, not being adequate. I have some unease with that. And the question I want to pose to you is this. When judges comment on your draft, genuinely, when you receive the comment, do you genuinely believe that they improve and help you, or is it a matter of conforming to what is going on in that court? Because they are seniors and they are assisting you. I just want to understand your true and honest feeling in the assistance that you got in relation to the initial judgment because I have a serious unease with what I'm hearing is happening at the Supreme Court of Appeal. Thank you.
Yes, I understand your sense of unease, and I think not so much today, but a few years ago, like when I first started acting, there were certain judges who have certain ways that they thought judgments should be written. It was my very first judgment in the SCA, so I was a little unsure because there is a different writing style in the SCA. One doesn't go through all the facts and etc. One tries to keep it concise and on the particular point. It was an interesting judgment because, in fact, I thought that I was going to dissent from everybody in that judgment. That was the Masangani case about the RAF and agreements. Because when we first started discussing it, they all said, well, you know, it's an agreement and the parties concluded it and etc. And I said, one needs to understand what goes on in the high courts, such as my division, where we get hundreds of RAF cases. And there is a scam going on. People are being paid money. You get an agreement and it says 2 million rand and the person sprained their ankle. And I said, we have to look at these judgments, at these agreements, because this cannot carry on. No wonder the RAF is bankrupt. So I managed to convince, well, I think Justice Meyer was already on that side, and Judge Wallace also came over. There were 2 dissenting judges in that matter. But I did think that this is my first case. These are very senior judges. I can learn from them. In the end, the judgment was structurally slightly different to what I'd prepared, but I thought that my judgment was adequate, but I took the advice and I took the comments simply because...
No, thank you. I think you have answered.
Yes, thank you.
Thank you, AP.
Thank you, Professor Moromokhai. Judge Weiner, you would of course know that when colleagues provide you with their suggestions, it is up to the scribe
Yes,
to decide whether you want to adopt or reject them.
yes, absolutely.
And indeed, some colleagues would even say so in so many words, here are my suggestions, please adopt or reject as you
Yes.
wish.
That does happen, and I have done that ever since I have been writing judgments in the SCA. As I say, I did, when there are valid comments and contributions, I will adopt them, but I'm also independent enough, I think, to believe that what I think is a good judgment is in fact so.
Thank you. Is there any other thing that you would want to draw to the attention of the commission before we release you?
Well, there's just some stats, if I can say that. Since I've been a judge, I've written, as far as I can see from the records, 224 judgments. There are over 30 that I could find only recently. For some reason, the earlier judgments didn't come up in my searches, but there are 30 that have been reported. Since 2018, I've written 70 judgments, and 13 have been reported. So I believe that I have the experience from my years. As I've stated, I don't want to repeat myself, and that experience can be of a benefit to the SCA for the time that I have left to serve and which time I would like to serve on the SCA. Thank you.
Thank you, Judge Weiner. Just bear with me for a moment. Judge Weiner,
Yes.
Judge President Mlambo
Oh, sorry, JP.
has a short question for you.
Yes,
Good afternoon, Judge Weiner.
yes.
This is basically a follow-up to the transformation questions that were raised with you earlier. I think I'm just asking for your views, if you have any, about how we can deal with it. My experience since I became JP of Gauteng, even with the labor courts, is when it comes to senior members of the profession, they do not easily avail themselves for acting appointments,
Yes.
both black and white. And the trend is it's the recently acquired silks who usually avail themselves even for permanent appointment.
Yes.
It is a hurdle, it is a challenge to us as heads of courts, because we need to address the challenge that has been mentioned here of lack of leadership from the female ranks in the judiciary.
Yes.
Do you have any comments to what I'm saying? Because we really need help.
I think that the seniors at the bar and I'm not sure of the attorney's profession because I wasn't a member, have abdicated their responsibility to both the judiciary and to the bar. If you look at the bar councils, they consist of very junior members. The silks are junior silks. None of the senior people avail themselves of those positions. It is a great responsibility, I concede, but it is something that is so essential for the administration of justice, for the rule of law, that those people make themselves available. And I'm not sure if this is what you do, but I would, if I can just give a little piece of unasked for advice, I would ask the senior silks to give you a time, throughout any time in the year, where they are prepared to serve for even 2 weeks, because having them on the bench adds gravitas to the bench. It will make people want to appear more frequently. We know that people are going to arbitration, and I think that if there were senior silks who don't avail themselves for a permanent position, but if they make themselves available to act for a certain period of time, I think that would assist. And as I say, I really do believe that the senior silks have abdicated their responsibilities.
Thank you, JP. Judge Winner, we have now come to the end of your interview,
Thank you.
and you are excused at this stage. Thank you.
Thank you.
You let me know when you are ready, Judge Matutani.
I'm ready, Deputy Chief Justice.
Are you comfortable over there?
Yes, I am.
Okay. My goodness. You hold a number of academic qualifications. A BProc, an LLB, diploma in trial advocacy, 2 LLMs, and another diploma in corporate law.
Yes, Deputy Chief Justice.
And I see that you would have completed, well, almost all of them while you're already working.
Yes.
How did you manage that? Where did you find the time?
Chief Justice, remember when the new constitutional dispensation came into being, it was important for some of us to go back to school to study afresh constitutional law. And I did a master's by coursework in, I think it was criminal procedure, constitutional law, and evidence.
We are struggling to hear you. Perhaps
Yes.
bring your mic closer to you.
Sorry about that,
Oh,
Chief
that's better.
Justice. I was just saying in passing that after the new constitutional dispensation, some of us found the need to go back to school to sharpen and acquire new knowledge in constitutional litigation.
You started your legal career in 1992. No, it was before that. Oh, you did your articles of clerkship, then immediately became partner.
Yes.
You started your own firm.
No, I first did my article of clerkship for 2 years.
Yes.
Then thereafter started my own firm.
Was that a successful practice? How did things pan out?
Yes, as time goes on, the firm grew and it became, at one stage, I had 4 partners. So we're relatively busy.
And you remained an attorney until you joined the bench in 2010?
Yes, I think around 1995, I received permission to appear in the High Court, and I did a lot of appearances in the High Court whilst being an attorney.
And in these 12 years, you have also acted at the Constitutional Court?
Yes, I've acted first as a judge at the Land Claims Court, then I acted as the judge president at the very same court, then thereafter